Hi, hoping you're doing great and welcome to our new lecture together. As we already agreed, our lectures is distributed between something theoretical, something more realistic, case studies, etc. This lecture today is going to concentrate on one of the theoretical background or aspects of political science. We're going to talk more about certain theoretical aspects and the theoretical landscape of certain phenomena. Let's start to talk about the relation between democracy, law, and constitutionalism. The idea of constitution or constitutionalism used to be a concern for each thinker and philosopher who already studied or deal with any aspect of political science or political phenomena, or for any thinker who is trying to explain the track of a democratic community. So let's try to analyze and see the relation and the pattern of this relation in a way. For much of human history, law was simply the will of the ruler. So it only reflects the idea of the majority willing, or at least the willing of whoever is ruling the country. Democracies, by contrast, have established the principle of the role of law for rulers and citizens as well. So instead of giving the privilege for only those who own governance to control and to reflect their willing, democracy created a new pattern, a new formula of law that includes everyone, citizens, government, etc., etc. So this ends in a very important concept which called equal adherence to law. This means that everyone is participating and confronting the law in the same sense. The rule of law protects fundamental political, social, and economic rights and defends citizens from the threats of both tyranny and lawlessness. Rule of law means that no individual, whether president or prime minister or private citizen, stands above the law. Democratic governments exercise authority by way of the law and are themselves subject to law in the other way. Citizens living in a democratic community or in democracies are willing to obey the laws of their society because they are submitting to their own rules and regulations. Justice is best achieved when the laws are established by the very people who must obey them. Whether rich, poor, ethnic, majority, minority, religious minority, political party, allow the state of peaceful opponent, all must obey the law. The citizens of a democracy submit to the law because they recognize that, however indirectly, they are submitting to themselves as makers of the law. When laws are established by the people who then have to obey them, both law and democracy are served. So it is, in a way, a very important relationship between democracy and constitution and law. If people will understand and realize the existence of law as the siege to protect them, definitely they will obey the law, definitely they will serve this law, definitely they will do their best to protect this process. But if they will feel that this law is established by the government or whoever is ruling the country, they will feel that the law is a knife over their neck. And in this case, definitely they will never ever obey the law. Another point that we need to talk about is due process. In every society throughout history, those who have administered the criminal justice system have held power with the potential for abuse and tyranny. In the name of the state, individuals have been imprisoned, had their property seized, have been tortured, exiled, executed without legal justification, and often without formal charges ever being brought. No democratic community or society can tolerate such abuses. Every state must have the power to maintain order and punish criminal acts, but the rules and procedures by which the state enforces its law must be public and explicit, not secret, arbitrary, or subject to political manipulation. And they must be the same for all. This is what is meant by due process. So due process as an idea, as a nation for political science or for any democratic community to give the punishment for everyone in an equal track and in the same way, to make it so clear and explicit why this person was punished and the relation between the crimes and the punishment. It should be very clear, very obvious, and no one should be not punished because he is belonging to a certain category. The entire idea behind the due process is that it is not only about punishment, it is also about fair, transparent, fair punishment for everyone inside the community. You cannot say that this is a democratic community without keeping the idea of due process, without giving the feeling that your rights are protected. No one can punish you without a legal excuse for this punishment. This is a very nice idea. This is a very ideal idea. And many thinkers were trying to explain what is the best practice to implement the idea of due process. And they contributed with several attempts. And many thinkers tried to explain the best way to implement due process. And based on all these, let's try to put like a common elements that might explain or might produce the best practice to implement the idea of due process, because as we mentioned, it is never possible to have a democratic community that lack due process. So how can we apply due process? In which level can we do this attitudes or behaviors? Let's see the following rules which have evolved in constitutional democracies. Number one, no one's home can be searched by the police without a court order showing that there is a good excuse for such a search. The midnight knock of the secret police has no place in a democratic society. So it is again, you are protected from the law itself. It is like the law is protecting you from the law itself. Number two, no person shall be held under arrest without explicit written charges that specified the alleged violation. Moreover, under the doctrine known as habeas corpus, every person who is arrested has a right to be brought before a court and must be released if a court finds that the arrest is invalid. So it is making the procedures to arrest people, to attack their freedom, more complicated, to forbid these actions. Someone can ask me, is it so important to put these procedures? My answer for this question is definitely yes, because in the early era of communities and before the current and modern age of democracies, definitely the authority of the palace and the authority of the government were dominant over all the rights. People were totally threatened by the palace. If a palace is arresting someone, no one can even talk about it. And it's not only in our Arab world, it was all over the world. A third conditional or constitutional track could be that people charged with crimes should not be held in prison for protected periods before being tried. They are entitled to have a speedy and public trial and to confront and question their accusers. So it is that still, if someone is accused for a certain crime, this will never make him a criminal. Still be innocent till the law proves the opposite. So even if someone is accused for certain crime or etc., he or she still has the right to be questioned in front of the court and tell his or her perspective or point of view or part of the story. Number 4, authorities are required to grant bail or conditional release to the accused pending trial if there is little likelihood that the suspect will flee or commit other crimes. Number 5, persons cannot be compelled to be witnesses against themselves. This prohibition against involuntary self-incrimination must be absolute. As a corollary, the police may not use torture or physical or psychological abuse against suspects under any circumstances. This is also was one of the most important points to talk about, because in the very ancient tracks, people were tortured in a very bad way, in a very unhuman treatments, just because they were accused for certain crimes, or at least they were suspected for these crimes. The other important point here, people who are arrested for a political background also were tortured with all kind of torturing, physical, psychological, any kind of torture. So this fifth condition is a very important to make it very clear that no one has the right to torture a prisoner, even if he or she did commit the crime. Number 6, persons shall not be subject to double jeopardy. That is, they cannot be charged with the same crime a second time if they have once been acquitted of it in a court of law. That if someone did a crime or someone did something mistaken, and the court just punished him for once, it's supposed to be over. No one has the right to punish him or her again. Number 7, because of their potential for abuse by the authorities, so-called ex post facto laws are also proscribed. These are laws made after the fact so that someone can be charged with a crime even though the act was not legal at the time it occurred. Number 8, cruel or unusual punishments are prohibited. This is one of the most important also elements or conditions. Um, no one can create a punishment. The law should make it very clear what punishment for which crimes. You cannot, as an officer or policeman, or even an executive authority, to create a punishment. This is totally forbidden. None of these restrictions actually means that the state lacks the necessary power to enforce the law and punish offenders. On the contrary, the criminal justice system in a democratic society will be very effective to the degree that its administration is judged by the population to be fair and protective of individual safety, as well as serving the public interests. In spite of all the above, this definitely doesn't mean people who commit crimes can be safe. Definitely no. But this is making it very clear that no one can accuse your dignity or humanity just because you did something wrong. But in the same sense, in the same level, you definitely will be punished with a very constitutional track of punishment if you did a crime, if you did something that attack others' freedom rights or the public interests. So it is all about making it very clear that your rights, your freedom are protected once you do nothing to harm others and the community. And once you do such actions, definitely you will be punished and obeying the law. No one in the same sense can touch your dignity, but definitely you need to pay for your actions. An important point also, we need to say that the balance between punish someone and protect their humanity, rights, and dignity is a question for each democratic community. That either we can see executive authority as over the other two authorities, or we can see the legislative authority over the other two authorities. But it is very rare to see the judicial authority who is handling everything. The only point that you need to be very accurate about is the existence of the law um, doesn't mean at all that um, people can be attacked, people can be tortured, people can be slaves for the law, vice versa. The law is serving people their dignity, humanity, even if they are mistaken. Okay, all what we were talking about drives us to a very important point. What is the tool that can serve as the theoretical background for all the principles we've been talking about? How we can guarantee that the punishments are there? Citizens are very aware of their responsibilities. What is called a crime? What could be a fair punishment? Um, I think all these questions and other important questions were the reasons why people needed and demanded to have what we call constitutions. Not only to have constitutions, but also to have written constitution. A constitution which state government's fundamental obligations and limitations on state power is a vital institution for any democracy. To be able to measure, to assess if this community or if the state or government is a democratic one, you definitely need to review their constitution. As we did with all the previous elements, it is very important to see a constitution not as an aim, but as a tool to implement, to perform democratic actions and attitudes. When we talked about constitutions, definitely there are certain points or factors we need to talk about to cover the idea behind constitution and to see how these tools, constitutions, are built and definitely uh, can be implemented in the best way to protect the human rights, to protect also the sovereignty of the community itself. Number one, constitutions as supreme law. A constitution defines the basic purposes and aspirations of a society for the sake of the common welfare of the people. All citizens, including the nation's leaders, are subject to the nation's constitution, which stands as the supreme law of the land. At a minimum, the constitution, which is usually codified in a single written document, establishes the authority of the national government, provides guarantees for fundamental human rights, and sets forth the government's basic operating procedures. Constitutions are often based on previously uncodified but widely accepted practices and procedures. For instance, the U.S. Constitution is based on concepts derived from British common law as well as 19th century philosophers' attempts to define the rights of man. Other constitutions, for example, is the result of certain committees deriving from the British constitution itself. For example, the Palestinian constitution is a mix between the Jordan and the Egyptian and the British constitution. The only point that I want you to understand here is the shape of the constitution definitely reflects the shape of the history of the community itself. It is part of the historical development. It is part of the struggle to establish a free, independent, explicit process of building the democracy inside these communities. Constitutionalism recognizes that democratic and accountable government must be coupled with clearly defined limits on the power of government. All laws, therefore, must be written in accordance with the Constitution. In a democracy, a politically independent just jury allows citizens to challenge law they believe to be unconstitutional and to seek court-ordered remedies for illegal actions by the government or its officials. Despite their enduring mounting qualities, constitutions must be capable of change and adaptation if there are to be more than admirable fossils. The world's oldest written constitution, that is the United States, I think, consists of 7 brief articles and 27 amendments, the first 10 of which are known as the Bill of Rights. This written document, however, is also the foundation for a fast constitutional structure of judicial decisions, statutes, presidential actions, and practices that has been erected over the past 200 years and which has kept U.S. Constitution alive and relevant till today. From this particular paragraph, we need to wrap up or summarize 3 very important ideas. Number 1, this constitution must be written, must be published, in which every citizen can see, read, and be aware of. Number 2, anything which is not written inside the constitution considered illegal. That's why these constitutions must be built in a very professional way to give the chance for everyone to be able to access the information. The second very important point that there should be a great separation between the government and the constitution, that you cannot give the privilege for the government to change the constitution or to control the constitution. The third very important point is that this constitution should be very dynamic, should be amended, should be changed and modified based on the modern conditions or the changes or the development of the community itself. And this is the exact reason why the United States democratic track depends on protecting the Constitution for a long, long time. It is all about keeping these constitutions updated, modified in a way that reflects the changes in economic, cultural, religious, social context and parallel level with the community itself. In general, there are two schools of thinking about the process of amending or changing a nation's constitution. If the changing of the constitution is a must, if the changing of the constitution is something no one can deny, so definitely we need to seek the best practice to implement these changes. As we said, we have two schools, two perspectives. One holds that it is best to adopt a difficult procedure requirement that requires many steps and large majorities for such amendments. As a result, the Constitution is changed infrequently, and then only for complying reasons that receive substantial public support. And this is exactly the model of the United States Constitution. This perspective says that it is okay to change, to amend, to modify the Constitution, but definitely the process must be very complicated. The condition to require such amendment is not an easy one. The other perspective, depending on much simpler method of constitutional change, which many nations nowadays use, is to provide that any amendment may be adopted by approval of the legislative authority and passed by the voters at the next election. That's it. By that, constitutions could be changed. Constitution revised and the fashion can become quite lengthy. Actually, what determine which track the community will go for? The answer for this question is the structure of the community itself. Okay, thank you so much for joining me in this lecture. I hope the idea of the relation between the law and the Constitution is clear now. And I hope you started to take note, because this is one of the most important questions you need to study very well for your final. Thank you so much. Be safe, and hope you are safe with your families. Good night.